Hi everyone. Just wanted to provide an update on last week's work. Thanks everyone who joined us in the Hangout. I thought we had a good crowd last evening. So thanks everyone for joining us there. Hopefully you had got some good information. Enjoyed chatting with everyone. I thought it was a interesting discussion. Thanks everyone for sharing your experiences and the knowledge that you had from your workplaces and your experiences you've had as patients and whatnot too. So I appreciate that. A few things that I wanted to share from last week's activities. The first thing was specifically from our chapter. Our chapter that we read was about policy implementation, various different items regarding rulemaking and operations evaluation of policy after it's kind of after the law has been created. We've talked a bit about that policy making process, so creation of the law and then what happens next. And I had talked a bit about this in the discussion board, but I know that we have so many posts, so not everybody sees everything in the board. So I did want to talk a little bit about this here. So when there's a law, for example, like HIPAA, so there's a law that says that hospitals or healthcare organizations, covered entities under HIPAA, have to protect, under the administrative simplification of HIPAA, there were certain things that were laid out about protection of information for patients. So what happened secondary to that were creation of various regulations. One set of regulations that came from that were the privacy regulations. Another set of regulations that came from that were the security regulations. Those security regulations is where that is where the encryption standard, or somewhat lack of standard, the what's considered an addressable standard, that's where that lives. When they create these regulations, this is what I wanted to talk a little bit about. What they do, and it does talk about this in Chapter 8, it's what's called the rulemaking process. So what the government organization will do, and some of you may be well aware of this. I know that some of you kind of work within this, and I may have mentioned this in last week's summary as well, but it's particularly pertinent to what we were talking about in the discussion boards. You'll actually the agency, in this case it would be CMS, Center for Medicare and Medicaid Services, they'll actually write a rule. They'll write what's called a proposed rule. They'll put that out there for review to the world, to the world that cares. So it would be, obviously, mostly healthcare folks. So the healthcare industry, anyone in the industry that is interested. It doesn't have to be a covered entity. It could be consulting groups. Oftentimes will comment. Legal entities like law firms, law consulting agencies that are involved in the law. Whatnot, they can all comment. Everyone will make comments back to CMS on this, and then there's a comment period. It depends on the regulation. It could be anywhere from 30 to 180 days, the comment period. And then after that comment period, then they'll take some time, they'll digest it all, and then they'll submit a final rule. And we've had some final rules that we've looked at here in class. They tend to be lengthy. And at the beginning, you'll see all those comments. Those comments are where CMS, or whoever is publishing the rule, all government entities will publish rules. That's where they're responding to the comments from the public. So those are the public comments, or they're paraphrasing the public comments and responding to them. So if you submitted a comment, you could see your comment published in there and how they responded to it. Either here's how we addressed it, or here's why we didn't address it. So that's the process, the rulemaking process, and how they would potentially address a change in the encryption standard. And I'll talk a little bit more about the encryption standard in a minute, since that was our discussion board. So I just wanted to talk about that because it is really important, and that's how the majority of of what we talk about from a mandate side, mandate standard in our industry. That's how they come about. Oftentimes a law will be created, but when we're talking about regulations that we follow in the industry, it's those those regulations are just that. They're regulations that are coming from CMS or perhaps from the state side. They're not necessarily a law. The legislators create the law, but that law doesn't give us the detail we need to be able to implement. So we may know from the legislator, well, they really want us to protect information, but they don't tell us how. So the government agencies need to create those regulations. The regulations tell us exactly how, so it's a little more detailed. But even though it's a regulation, it's still secondary to that original law, and the regulatory process actually creates, because there's public comment and then final rule, it is like a law that we have to follow. It is secondary. It's a regulation, and we do have to follow that just as if it was, much like a law. Okay, so I'll talk a bit about the discussion board. So we talked in the discussion boards about the process of of encryption, and should encryption, the HIPAA security standard currently does not require encryption, but should we require encryption? And there was, I think, probably a good majority of folks thought that encryption, they were surprised that encryption on data in the healthcare industry was not required, and felt that it should be. And I think, and I had shared this in the discussion board as well in a few spots, but again, I know not everybody sees every discussion post, and that's just fine. There's a lot of them in there. We have a lot of students. So I think the reason that it was considered what they call, in the security requirements, there are things that are called required standards and things that are called addressable standards. So things that are required are things like access control. So all providers have to, or all covered entities, so it could be an insurance company, it could be a physician office, it could be a hospital, they all have to have with access control. So they all have to have individual sign-ons for staff. They all have to control that access point from a technical standpoint. You can't share sign-ons, you can't share passwords, all of that. You have to have unique access control points for your staff. However, and that's a required technical standard, but they consider encryption as an addressable standard. And the reason that they did that was because if you have, say, a very small physician practice, maybe a 1 or 2 physician practice, at the time that keep in mind that this rule was written in 2003, 2004 to be implemented in 2005. So at that time, I think it was felt that the expense of encryption for a very small physician practice would simply be too much. So it was, the encryption was to be implemented as appropriate based on your organization. So it was kind of expected that a large physician organization or a large hospital organization with a large IT department would likely be encrypting their data, whereas a small 1-2 doc practice probably not going to be encrypting data. That being said, there are times when you look at, if you look at information that's being shared, if you look at information being shared, maybe an email that's going outside of your organization, something like that, it is always your responsibility to protect that information if it's going electronically outside of your information structure, outside of your infrastructure. So how otherwise would you protect that, guarantee that data's protection, unless you encrypted it? So there are times that, outside of encryption, how really would you protect that data? And that's kind of been the question over the years, where although they've said it's an addressable standard, how really do you protect data unless you would never ever email or even fax nowadays? Many of us use a fax machine that will turn the fax into an email, or even voicemails that turn voicemail into email, and are sending things electronically. So anything that's sending electronically, that's turning it into like an email situation, something that's becomes an electronic progeny of information that has PHI in it. It doesn't have to be a medical record. It just has to have protected health information, name, date of birth, address, All of those things are considered protected health information that can become problematic for your organization. So just something to consider. Sorry about that. Had a small electrical issue. So one other thing that we want to consider that we talked about in the boards was ransomware. So ransomware is also something to consider from a security standpoint. So ransomware is obviously when, like the WannaCry attacks that we had seen a bit earlier this year, where they're typically through phishing emails, and I know some of you had shared experiences where your organizations are actually testing phishing emails, kind of sending out test emails, kind of lure you with phishing emails. And I'd be willing to bet that there's not a single one of you, and I know I've had them as well, that in your own personal email has gotten one of those. And I know my mother gets them all the time, and sadly she falls prey to them. So, it's really important that we as organizations train our staff not to fall prey to those, especially in healthcare organizations. A lot of times it looks like it's coming from someone in your organization, maybe someone in IT. They'll grab somebody's name, maybe a CIO or a director of IT, and they'll be sending that out to make it look like it's coming from someone high up, and they're just begging you to click on that, and then they get access to your system. And then what happens in that case? They take something from your system, typically a portion of your EMR data, something that hold it hostage, hold it for ransom, and they want payment in Bitcoin to get that back. The problem is that if you don't have that data encrypted, then that is a breach, security breach, privacy breach, and will be subject to the breach notification requirements typically. But if you do have that data encrypted, then you have a problem from a phishing standpoint, and you may very well have other issues to deal with. However, you likely do not have a privacy breach unless you find that they've somehow been able to hack that encryption. So typically and that's often not that's not what they want. They just want money. They're not looking to hack that data. That their point is money. That's often what their purpose is. So consider that. Even with the ransomware, although there's always the chance that they can hack the encrypted data. That's often not their purpose. If that was their purpose, they'd probably just hack into your system and steal the data, and just exploit the what they could do with all of those pieces of information. Because oftentimes, if a hospital can back up their systems and they don't have issues with the encryption, they won't pay the money to the people that they have to pay the ransom to. So very very interesting situation. But so it's an important combination of both having encryption and providing training on things like malware and whatnot. Very important combination. So that's about it this week. Hopefully you found the work from this week interesting. We also had some information about King versus Burwell to take a look at. Important case about specifically about the subsidies for patients under, or for enrollees under the ACA when that was kind of tried. One of a few challenges to the ACA that never occurred. Of course, we're having our own challenges to it now, not so much in court, but within the government itself. So an interesting case in itself. So looking forward to taking a look at the papers that you submitted from last week. Haven't gotten to that point yet, but looking forward to that. And any questions on anything, please just let me know. Looking forward to seeing you in the boards this week. Thanks so much.